Thank you, Mr. Speaker. I'll ask you to bear with me. Usually when I get up to speak about something, I use a very loud voice. I'll probably be a little bit quiet today. I hesitated for a long time on whether I would speak on this bill because it touches me in ways that I don't believe it touches any other member. I believe the goal of protecting victims from abuse and deadly violence should be at the top of our lists of things to do. And I appreciate all the colleagues who brought stories from constituents in their districts here. But I want to tell you a first-hand story. First-hand story because I am a 30-plus year survivor of serious domestic violence. I was punched, I was slapped, I was kicked, I was stabbed. I woke up one morning with a loaded gun to my head. I know what it's like to be a victim of domestic violence because of the time frame when that happened to me. This was the mid-'80s, and I was a young man in my early 20s. I didn't realize there were resources out there. And, quite frankly, this is not something you go and you talk to your colleagues at work about when you're a young, up-and-coming male. It just wasn't acceptable to talk about. It took me about 20 years to get over that. And I made a lot of bad decisions in my life. I stand before you as a survivor of serious domestic violence. And my heart goes out to every victim of actual domestic violence. It is not something you ever want to live through. Despite that, Mr. Speaker, I must stand in opposition to this bill because I think there is a serious flaw in it. And the flaw also has very personal ramifications for me. And the flaw, Mr. Speaker, I don't remember the exact words they used, but the maker of the bill inferred it in her statements, and it was echoed by the gentleman from Philadelphia. The assumption that every person who asks for a protection from abuse order has actually been abused. There is a very low threshold of evidence required to get a protection from abuse order in Pennsylvania. How do I know? Because some years after I was actually abused, like I told you about before, I was abused again. And by that time, I knew about the PFA system. So I went to the courthouse. And at that time, there were now there's domestic violence advocates who are there to help you. The only person there to help me was the person who worked in the law library. So they asked me to write a statement. And I went into the judge. It was my first interaction ever, first time I had ever met, one of the common pleas judges in our county. And he went over my statement. He asked me to repeat my statement to him from memory. And he issued the PFA, a temporary PFA order. That was all that was needed. I didn't need a police report. I didn't need a bruise. It's just me standing before the judge. And there is no higher standard of evidence when you carry through and attempt to get a permit or a final PFA order. It may be just the two parties standing in front of the judge, one saying this happened, the other one said this didn't. Right now, our judges have the discretion to determine the terms of a final PFA order. Put yourself in that judge's position. If you have two people standing in front of you, one says something happened, one says no, that didn't happen, what do? If there's no other evidence? If there's no other evidence other than that, you err on the side of caution. And you do what the Protection from Abuse order is intended to do. You put time and distance between those two parties. If you want to add any other provisions to that final order, you as a judge have the discretion to do that, based on those two people appearing before you and your impressions of those two people as that process unveils. I can also tell you that all it takes is one person's word to get a PFA. Because before I came here, a few years before I came here, and this is so ironic to me based on what I had gone through earlier in my life, I was falsely accused by someone of abusing them. That person filed and successfully got a temporary PFA order against me. Even though that person had called the police to her house and the police made no report, even though there were no marks, bruises, injuries, anything like that, a temporary PFA order was issued. And I was met at my home after work one day by the deputies who showed me the PFA order and came in and they took my firearms. I complied because I knew how the system worked, because I was on the other side of it. But let us not, and I've seen another colleague who posted this on Facebook, that they were standing with those people who were guilty of abuse. A PFA hearing, a final PFA order, does not necessarily include any kind of guilt beyond a reasonable doubt. It is a preponderance of the evidence. As such, the PFA system has a flaw in it. It does have a flaw. If it didn't have a flaw, 48.4% of these temporary orders would not be either withdrawn or have their plaintiffs not show up for court. I'm not saying it's too easy to get a PFA order. We need to have that system in place. And I could certainly vote for House Bill 2060 if the condition was you have a final PFA order accompanied by a conviction of some sort of crime beyond a reasonable doubt. But 2060 doesn't include that. You know, the other members of this caucus know more about the gun issue than I do. And if you don't believe, Mr. Speaker, if you don't believe that this system can be abused by people who have not suffered from domestic violence, I ask you to contact divorce lawyers and family court lawyers in your district for a little feedback. The system has been weaponized by some, to the great detriment of those actual victims of domestic violence, like me, who need those resources to keep them safe. I believe, as others have already stated, that this bill can be fixed. I believe we can get this bill to a place where it meets everyone's objectives, protecting victims and safeguarding our Second Amendment rights. But it's not there yet.